Well, we're going to shift gears, but it actually is a great segue, because what we want to talk about next is about these people that Mercy just mentioned is going to make decisions for our family when we're no longer the ones, let's say as parents, in the decision-making primary seat. And so conservatorships and alternatives to conservatorships is the next subject we're going to tackle for the next period of time. And I'm going to ask Mercy to basically give us kind of the overview of that category and what's going on in a real-time basis.
Sure. So when a family comes in to talk to me about whether or not to do a conservatorship, it's typically perhaps the year leading up to the 18th birthday. So what you have to understand is that the law says at age 18, unless there's a court order stating otherwise, every individual is deemed to have legal capacity to make their own decisions. And so for some people, that's going to be problematic at age 18. Perhaps they're not ready to make those decisions. Perhaps you're not sure if they'll ever be able to make those decisions. And so there are different things that we can put in place. Sometimes it involves a conservatorship, which is an actual legal order that states somebody else has authority to make decisions for this person. And on the other end of the spectrum, if the person has some capacity, sometimes we're able to put in place durable powers of attorney, healthcare directives, to allow somebody to assist the individual with decision making. And there's a whole continuum of what that can look like, everything from durable powers of attorney to a full-blown conservatorship. And then in California, we have something special called the limited conservatorship, where you can pick and choose particular powers that perhaps the individual needs assistance with, but you don't want to get a full conservatorship.
Are there any questions from the floor?
We set up a special needs trust.
Microphone? We have a microphone, so everybody can hear.
We set up a special needs trust when my daughter turned 19 and she was going to move out into her own house. The attorney advised us not to conserve her, and now I'm thinking that we should, because she decided she might want to get a surgery, which was not advised. And she has the power to do that. So I want that not to happen. So I'm curious, what are the reasons not to have a conservatorship? And what suggestions do you have in this situation?
Sure. So one of the reasons for not having a conservatorship is essentially asking the court to take away somebody's legal rights. And so when you go to court to ask the court for that, both the court and the families are really looking at where's that balance? Where's the balance between protecting the individual and taking away their rights? And sometimes it is necessary to take away some rights to offer the right protection. Other times it's not necessary to take away those rights. And something that we often discuss with families is that, people with capacity make bad decisions all the time, and that sometimes it's just a bad decision and not a lack of capacity. And so what we use in determining whether or not it's a capacity issue is there's a specific form that the courts ask us to obtain from the doctors called a capacity declaration. And the doctors are required to fill out very specific questions about the individual's cognitive processes, short-term memory, long-term memory, abstract thinking, things like that.
Also, if I could add, in California, with the limited conservatorship, as part of that process, the judge, the court asks the regional center for their recommendation as to whether any of these up to 7 powers that the family member is petitioning the court to take away from their loved one should in fact be taken away. So the regional center does a report to the court, and regional centers tend to be pretty conservative in recommending that the powers be taken away. I've had some conversations with supervisors at regional centers. It does not matter how disabled the person is, they're going to fight to the end to not have absolutely any rights taken away from that individual. The court does not have to abide by the recommendations, but it has to take into consideration. So You've probably run into that a few times.
Quite a bit. And then, there's always 2 powers. So maybe what I'll mention quickly are the 7 powers, because Jim,
Yeah.
you mentioned it too. So when we talk about a limited conservatorship of the person, when you're asking the court to give you authority over certain personal decisions for the individual, you're looking at 7 different powers. The power to control educational decisions, where they live, the right to make a contract, the right to make for medical decisions, the social sexual contacts, and we'll get into that a little bit, the right to control marriage, and the access to confidential documents and papers. So the 2 hotly contested, or most hotly contested powers, and particularly by the regional center, are the social sexual powers or contacts, and the power to control whether or not the person can get married or enter into a domestic partnership. And I understand the regional center's position on that, which is that they feel these are inalienable civil rights that people have that nobody should be able to take away regardless of the level of disability. I would say, given my job and what I've been doing, what I've seen, I think there are certainly circumstances in which you would ask for those powers. In particular, I've had a client that was in a day program and had a worker take this person down to City Hall. The individual with the disability was very high functioning. The worker got married to the disabled individual in order to get a green card. And fortunately, we had that power in the conservatorship, and we were able to go down to City Hall and waive the letters of conservatorship, and they immediately annulled the marriage. Otherwise, you're going through a whole court process to do so.
There's a number of, and this is a question I'm sort of asking on your behalf. There's a number of alternatives to conservatorships. Now, just for clarification, guardianships are similar, but they're for children, and conservatorships are basically reserved for adults, just for some people confuse those concepts. Number 2, there's quite a movement afoot in this country by groups called self-advocates. Wonderful label, sounds great. Aren't we all self-advocates? But some of these groups are basically trying to do away in all the states with conservatorships, because they believe in their mind that parents or conservators have an undue influence and manipulative effect on their charges. And so they would like to basically give full civil rights to, in this case, the conservatee. But as we know, many of those conservatees have no capacity that we've touched upon to basically make any decisions. But those self-advocates are so driven by the civil rightsness of all of that, that from heck or high water, they're going to have those rights. So it creates huge problems. So there are other models called family advisory groups or committees, where the trustee sets up a number of friends and family, whomever, to basically act as like a committee to make the decisions. There's another phenomena going on called supported decision making, and that's basically similar to what I described as a team that comes together and conducts a person-centered planning, something we're going to talk about later, because person-centered planning is a huge subject that's now embodied in federal law. So maybe you could comment a little bit on some of the alternatives, but maybe the quick pros and cons of some of those models versus conservatorship.
Absolutely. I mean, the great part about some of the alternatives is you are preserving the individual's rights. So if you're talking about putting a team in place to assist in decision making, using a durable power of attorney or a healthcare directive to grant somebody some authority to assist the person with decision making, that can be a great collaborative effort. I think where that may break down is if the particular individual with a disability, if their particular situation is such that they are likely to revoke the durable power of attorney, so it's revocable by the individual with a disability, then you can end up in a pretty tough situation. If the individual with a disability is susceptible to undue influence, they get somebody really bad in their lives who says, hey, mom and dad shouldn't be helping you make decisions, you're an adult, you need to get rid of your durable power of attorney, then we get into some pretty bad problems. And so, in evaluating what the appropriate vehicle is, we'll sit down and talk about how is the individual functioning. Is this somebody who, I have some clients who drive cars, go to school, they're going to college, they're doing great, but perhaps one particular area of their disability is that they're unable to stop some impulse control, and that impulse control has gotten them into some kind of sticky situations, and we might really think twice about the durable power of attorney there.
I want to ask Jim and Dan to weigh in a little bit on when they're dealing with a family that has a conserved child, what key issues arise out of that legal relationship that affects getting public service benefits or actually making decisions about managing assets in a trust or whatever, either one of them?
Yeah, with Social Security, they do not recognize really the conservatorships. They're sort of an entity unto themselves. They will decide if they will do one thing. They will decide if an individual needs what's called a representative payee, and they will do that in their sole discretion. If the person's conserved, you can go up to the window and say the person's conserved. We need to have the parent. They will say we will make that determination, and they will talk to the doctors again and see whether that's necessary. So the conservatorship, power of attorney, none of those things carry any weight with Social Security. It's their own agency, and they're going to make the decision.
Although I would mention anecdotally that I've had a couple of clients recently where we'll put in the conservatorship, and just for austerity's sake, the power to sign public benefits applications. And I've had a couple of people say to me they were able to take those letters of conservatorship down to Social Security, and it was just sort of further evidence, maybe a shortcut to that evaluation.
Yeah, what's interesting, because I deal with all these agencies in the trenches every day, is it's all over the place. That could not be a rule. It could just be that particular claims rep decided to do it.
Right.
So it would be interesting to see if it's actually written into a regulation.
Dan, anything to add?
Yeah, and for me on the conservatorships, so I don't deal with the person side. There's two types of conservatorships here in play. There's one, the conservatorship of the person, and that's what we've been discussing, but there's also conservatorship of the estate. So if conservatorship of the estate then has a conservatee and a conservator. So I would deal with the conservator or the conservatee on managing the assets for that individual, and we typically see it more in elderly folks for the special needs instead of the special needs trusts. So in dealing with them, the couple things about conservatorship of the estate too is it's a legal proceeding, right? So that you have to follow California probate code in order to invest it. And oftentimes, excuse me, if you're working with your typical investment advisor, they're not going to understand the rules and the laws when it comes to conservatorships. And so you want to make sure to work with someone who has an understanding of financial planning for elderly folks, individuals, and special needs trusts. So that'll help keep you out of a bad situation.
This gentleman has been waiting very patiently. If you got a microphone, if you want to have a question, raise your hand so we get the microphone to you and we can.
Thanks, Larry. Not to sound crass or anything, but if you conserve your child before they turn 18, you can do anything you want in terms of setting up the conservatorship, right?
So you can't institute a conservatorship for somebody who's not age 18. You can begin the process, but the court order will not be effective until the 18th birthday. Prior to that, you just have the authority you have as a parent.
You're the parent, yeah.
Thank you.
Yeah, I have a question regarding co-conservatorships. In the past, it seemed like the regional centers and just everybody, the schools, whoever, just assumed that parents would be co-conservators. My question has to do with when the situation changes. Let's say you set that up at 18 and then something happens, one of the parents dies or you get divorced. It can become a really huge problem in terms of the successor conservator and who's going to decide that. And then even finding a successor conservator in terms of if there's no family members readily available. So I'd like you to address, one, how do you find a successor conservator? And two, what do you do to avoid, or if you're in the process of a disagreement with a co-conservator? Because things can change over the years. And then that can become a real problem for both the conservatee and then the relationship of the conservators.
Right, so what you're talking about is that conservatorship continues unless one of two things happens. Either the conservator dies, and then that means that although the conservatorship itself continues, that particular conservator is no longer a conservator. Obviously, they've passed away. Or if the court is petitioned to terminate the conservatorship, then you no longer are conservators. So, for example, your first question about if a co-conservator dies, the remaining conservator would, of course, continue acting as sole conservator. What I sometimes find families do to head off some of those contingencies is to also appoint a child as a third co-conservator. So I've done co-conservatorships for up to 4 people. It's a little cumbersome, and the court isn't always happy when I do that, but I think that the alternative is that if you are left with nobody serving as conservator, but the conservatorship still exists, as you point out, you have to then locate a conservator, and you have to go back to court to petition to have that person put in place. In that particular situation, if there is no family member who's willing to step in, then we begin looking at professional fiduciaries, professional conservators. If there's no money to support that, sometimes the public guardian's office will step in. Yeah.
I'm going to take your question after I inject something that tails off with the comment. So something that you need to understand, and I'll ask this panel to clarify, is in the trusteeship, we talk about successor trustees, and we have the power to nominate and name who those successor trustees are. And one of the questions earlier from the floor was, how do we keep the music playing well beyond our days? In the conservatorship arena, there's a different animal, because we as conservators, my wife, Betsy, and I are co-conservators, that young man against the wall, Peter. But we cannot select a successor conservator. So would you comment on how successive conservators come into play, and is there anything, if at all, we can do as active conservators to kind of influence what the court will ultimately do to appoint what we would call a successor conservator?
Absolutely. So in your legal documents, your other estate planning documents, perhaps your will, some of your other legal documents, you can appoint what we call, you can nominate a successor conservator. Now, it's different than designating a successor trustee. When you nominate a successor conservator, it's essentially you standing in court saying to the court, this is who I would have picked if I was here. And the court takes that very seriously. Nevertheless, that person still has to go through the court process of being interviewed by the court investigator and has to go before the judge, and the judge has to say whether they feel this person is appropriate. And I think that's actually a good thing. I think for some people it sounds cumbersome, but if you think about it, you might be looking at 20 years down the road, and the person you picked as a successor conservator when you originally did your documents, something may have occurred in their life where that's no longer going to work, and you don't want them to be successor conservator.
Thank you. This gentleman is very patient.
Is there less scrutiny to get a power of attorney rather than a limited conservatorship?
So the court does not have to approve the power of attorney, but what we have to evaluate is whether the individual has capacity. So usually the attorney would have a meeting with the individual by themselves, ask them some questions, try to evaluate the capacity level. I also like to get a doctor's evaluation, determining what exactly are we putting in the power of attorney, and does the individual understand what this is and have the ability to make this decision?
Mike, you want to add to that?
As a practical matter, I think my experience is that there's actually, I would call it a sliding scale of capacity. Mm-hmm. And what I mean by that is if an individual has no money, no resources, is limited in what they're able to do in terms of functioning in the community, the likelihood of somebody abusing a power of attorney, et cetera, is really minimized. And in some situations, signing a power of attorney could conceivably keep somebody out of court. Well, conservatorships absolutely have their place. If the goal is to avoid that, I would say there's a lower bar in terms of capacity. I may be a little more forgiving than, frankly, some attorneys. If a person has some sort of identification, if the document can be notarized, and they're functioning at some reasonable level, I wouldn't push that issue as much as if somebody, again, is out there really functioning avidly in the community, maybe has some money, has resources. So I actually tend to individualize the decision, I think more than many do. So far, it hasn't gotten me in trouble, and I think it's been pretty practical.
Microphone.
So I have 2 kids who are very severely disabled, nonverbal, autistic, and pretty bleak horizon in terms of successor conservators. Hopefully I'll live a good long time, but eventually I won't. And so I have this idea, and I just would like feedback from all of you about starting a new nonprofit called something like, working title, Autism Life Care Partnership, which would be basically professional conservators and trustees who would be mission driven, right, to provide this successor parent role, right, take over for them. And I only know of really one entity in the Bay Area that's doing anything like this now as a nonprofit, and I'm wondering if you know of other entities. The one I know of is called Good Shepherd Fund. And if you have any thoughts about the creation of this sort of nonprofit.
I'm somewhat, there's one in Michigan that, it wasn't exactly that, Jill. I mean, the idea was to sort of acknowledge the need, the shortage, and one of the, such a challenging thing is, let's say you're in your 40s and your kid is teens or 20s. The person who will take over as trustee, or maybe somebody to be a conservator, that need might not come up for 40 years. So you look at family members, you look at individual fiduciaries, and the perfect fiduciary today probably won't still be practicing that many years down the road. I mean, it's a really tough practical thing. So again, that was exactly what they were focusing on, in the same idea, slightly different direction, but it didn't get off the ground, and the reason it didn't get off the ground is they couldn't get enough business, enough conservatorships to generate enough fees to maintain the program. They tried to really be very giving and non-profity, which I ran a nonprofit for 10 years. I mean, I understand it has to be a business. It can't just have a big heart. So I don't know, I think that's extremely tough. I support the idea. I think it's wonderful, but tough.
I know one organization, Jewish Family and Children's Services in San Francisco. They act as conservator and trustee for special needs trusts. One of the issues when you become a conservator, you have to be bondable, right? So you have to go to the court and you have to be able to get a bond. There's not many organizations, I don't think, that they give bonds to. I know they will give a bond in the name of the organization, Jewish Family and Children's Services, but for other fiduciaries that might work together, they don't give it to the fiduciary name, they give it to the individual. So that's one issue that might play into it, I'm not sure, but so it's a great organization.
Yeah, I was going to mention them as well. They've been around for over 100 years, and so they've got that background of having done this for a very long time. They'll be around for a long time.
You're a great crowd because you're already really touching on the track we're going to cover after the break. But just one kind of overarching thought. As you're making decisions for fiduciaries, and that's another one of those words that actually is both a noun and I guess a verb. Everybody that's taking care of our family affairs essentially has a fiduciary responsibility to their client. But we're a professional fiduciary, I guess, is basically a label of a function of really making and acting these decisions on behalf of in our cases, our proxies in due course, our successors in due course. But there is one thing to think about, and when we get in that track, I'll ask for input from the panel, is there are professional fiduciaries around there that are essentially holding out their shingle. Could be a one-person, one-woman operation. They've been doing it for 30 years. I know a number of these professionals, and they're phenomenal. But they don't stay in business forever. They don't live forever. So you're already going to have, for all of this, a succession plan. So if you think in terms of an institution that maybe has got the test of time of being in business for 50, 100 years, maybe you start thinking you need more of an institutional type agency or fiduciary that will kind of hand off within that organization. But as we will get into it later, it comes with a price. Sometimes there's a fee structure that can be prohibitive. And they basically are held to much higher standards of care because they are really third parties. But there's a trade-off that they may last for the next 100 years, but it comes with a tail. So we want to touch upon that in the next track because really, I go back to the railroad converging on the horizon metaphor. This is one where other people, well beyond everybody in this room, is going to be handling our children's affairs. And a fiduciary may be a solution to that, but how you pick that fiduciary is a decision unto itself. So, and this lady's been very patiently waiting to ask the question.
So I have a little two-part question. My grandson has he doesn't have the cognitive ability to make decisions, so we're looking for full conservatorship for him. He will be turning 17 this coming January. How many months we've been told that it has to be in place before he turns 18, I mean, without a doubt. So how many months in advance before he turns 18 would you suggest we get it in place? Like, 3 months is sufficient, 6 months?
So I would say reach out to your attorney about 6 months before he's going to turn 18, and your attorney can kind of give you a timeline for when to start the paperwork. So the idea is that every county has a different calendar system, and so, you know, if you were to tell me this is in Marin County, I would say, oh, you know, we can get the paperwork done 3 months ahead of time. Some other counties I know in the Bay Area are setting this out, you know, 4 months at a time at a minimum. I'd want to get that started a little sooner. If you said the situation was a little more complex because perhaps he has money in his name and we need to do a conservatorship of the estate as well, we'd want to build in a little more time to that because there may be other pieces we have to plan for.
Alameda County.
So Alameda County is setting a lot of their matters out a minimum of 3 months out. So I would, you know, say 4 or 5 months to begin the paperwork.
Okay. So my last question is, what is the price range usually for, what are you looking at for conservatorship?
It depends
normally?
on what needs to be done. So I like to quote a flat fee if it's a conservatorship of the person. If it's a conservatorship of the estate, you're really looking at a little bit of an unknown because there may be some moving pieces. Usually for myself, I charge at an hourly rate for that just because you're going to be interacting with the court in a way that's unknown.
Well, we'd like to get maybe the conservative ship going first, and then even after he's 18, we can always work on a trust. Is that correct?
Right, exactly.
Okay. All right, thank you.
Lady, right up here. Raise your hand, we'll get the
Right here.
microphone to you. Thank you.
So what terrible things will happen if you don't get the conservatorship in place before by the time they're 18?
So I think it really depends on the individual and what their particular issues are, and then also if you happen to be having any issues with physicians, the school, any, you know, sort of public entities. So let me give you some examples. In terms of the individual, if they are super excited about turning age 18, then they're going to go out and apply for a credit card the minute they turn 18. You might want to get that in place right away. You know, in terms of, for example, the school, and I don't hear this as much anymore, but I used to hear more often that some public school systems were bringing the kids in and saying, hey, you're 18, you can sign yourself out of here, you know, and so I think some parents have had concerns about that.
We have time for maybe 1 or 2 more questions in this section. And over here. I'm sorry. Too close to the forest to see what it is.
I have a 34-year-old son who is not a problem
Put the mic up.
has no problem with
Microphone.
obedience. He obeys us very well. My concern is what will happen once we're gone, because there are a number of organizations that take care of it in this area, but having been a bureaucrat, federal bureaucrat for 30 years, I don't trust any bureaucracy. I mean, they're all well-meaning, but everybody looks out for their own interest. I have trustees, a friend who's 20 years younger, and then the younger son who will take over. But I need a legal situation in which somebody could represent him. Somebody could say no, to any organization that's handling it. At this point, it's us. Nobody's asking for it because we're parents and we're there and we're very engaged. But one day, which is approaching sort of all too fast, we're not going to be around. Who is and what is the legal situation in which I can pass on that authority? Because I have people whom I trust. Moreover, one of them is a Stanford trained lawyer. Wow. But nevertheless, that's not her field. Right. We need to come up with some right sort of conservatorship or whatever for him.
So just, I want to make sure I understand the question. You're really speaking about the personal needs, the personal decisions, things that might not be covered by a trust. Do I have that
Yeah,
correct?
because he listens to anybody
Yeah.
who he deems to be an authority. A doctor, his nurse, the secretary, his counselor in one organization, a counselor in another. And this, usually we resolve this sort of thing, just, cool it, But, and they also know that there is us, the organizations.
Right.
That at some point there's gonna be that nasty, wolf mother, who will intervene. And they don't argue, oh, is he on a conservatorship or not? Nobody asks that.
Right.
Ask us because we're parents. How we can pass this sort of, authoritative position to somebody else? I know that our son would listen. I mean, I'm not so sure about his younger brother. That's another story. His younger brother, I mean, what's that? But he would listen to our sort of, to our friend who is, older than he is. She's a woman. She's not his brother. So how do we pass on this, this? I mean, what kind of legal situation? He doesn't need much conservatorship. He knows right from wrong. He cannot handle money because also doesn't want to know how to handle it. I suspect. Otherwise, he lives. But he needs supervision. And how do I avoid over supervision? For example, somebody wants to move him somewhere else. How do we deal with it? And he likes where he is in Belmont. So how do we deal with that?
Well, it sounds like, if he's willing to listen to whomever is put in place. Can you hear me okay?
I'm a professional occupational disease of teachers. I speak loudly, but I don't hear very well.
Okay. So it sounds like he's willing to listen to whomever the authority figure is in place.
Yeah.
And so in that situation, it may very well be appropriate to have a power of attorney. And then that's actual legal authority to make decisions for him in those situations. And those entities will recognize that. And what you'd want to do if you get that in place is make sure that everybody has a copy of that.
Yeah, so they know that there is somebody else out there.
I'll add a couple of points. For that individual, when I would prepare the special needs trust, I might have a special section where you're speaking in the trust, you're creating the trust. And you would say, if it's you alone, you'd say, I am very concerned about, and you identify what you're concerned about. That's different.
Yeah.
That's the second point, actually. In the special needs trust, you can say, I want my trustee to be an advocate in the context of whatever so you very specifically identify powers. It might not be powerful enough to carry the day, but it's going to help.
Yeah.
And the second thing is indeed what many of us call a letter of intent or a letter of guidance, where you write out what you want the trustees and whoever's going to take over and manage your kid and take care of him when you're gone, you list your concerns, the kinds of things that only you know about your kid that other people would take years to learn unless you wrote it out for them. Another thing I would do is that since you're saying that he's compliant, functioning, it sounds like he could sign, as Mercy said, could sign a power of attorney and an advanced health care directive. I wouldn't use a simple form. Again, if he's going to be compliant at this point in time, and if you have specific issues that concern you, use his compliance. Specifically go to the issues that you're concerned about and have him specify that in this context, I want this done, or I want this person to help me with decisions. So, I think you can be very specific and hone in on your worries and really develop a plan. You can't control it utterly, but you can help.